So good morning. I'm going to turn this over to the criminal law section leader, Joe Tully, to do the introductions.
Okay, good afternoon, everybody. I'm very excited about today's webinar. We've got two great people, two great experts, two great legal minds. And we're going to, as per the goal of this section, is to raise the level of practice in Contra Costa County for the criminal law section. So we've got Panagiotis Prountzos, and he's going to be talking about his approach to DMV hearings. And we've got Peter Johnson, and he's going to be talking about his approach to DMV hearings. And again, we want to learn as much as we can from these experts in the field. So Panagiotis, why don't you give a brief introduction in terms of your experience and qualifications to all of those who are listening.
So hi, yeah, so I opened my practice in 2013, and since then I've had an emphasis and focus on doing DUIs, and I've found it really beneficial. It's helped me professionally proceed with really attacking the DMV hearings with a high level of seriousness, which I'll go over how I attack them compared to just strategically.
Okay, and Mr. Peter Johnson, why don't you give a introduction, even though you also need no introduction, but in terms of your experience and your approach to DMV hearings.
So good afternoon. My name is Peter Johnson. I'm with the law office of Johnson & Johnson in Walnut Creek. I practice with my wife, Karen Johnson. Basically, back in 1992 or so, when I was becoming a lawyer in going into 93, so actually around, taking the bar and all that, Karen was very interested in criminal defense. I was not. I never had any intent. I had no desire and never thought I would. And then I started practicing, and we weren't together initially as far as practicing law together. And, I got my first criminal case, and it was a DUI. It was my first trial. I was very young, very new, and it was a lot of fun. What kept me going in criminal defense was the fact that it is very easy to wrap your head around the fact that people are getting, taken advantage of in the system, that the system's very draconian, that the penalties associated with it are way out of whack. And it doesn't matter, the constitutional rights, whatever. It's very easy to do criminal defense because it's the right thing to do. So after doing criminal defense for a while, I happened to go to I was getting a few DUI cases, so I happened to go to the National College DUI Defense Seminar. And there was a guy there, his name was Felipe Pacencia, who just recently passed away. And Felipe was awesome as a speaker and really turned me on to the whole DUI thing. And I then started really training myself on the National College DUI Defense stuff. And I can't emphasize enough, anybody doing this really needs to get into the training aspects of it. But anyway, I've done hundreds of hours. I go throughout the country speaking to people on various aspects. There's a perception that my strongest point is having to do with the science of it. I don't know if that's necessarily true. It is a strong point. I can't say that it's any more strong than the litigation aspects, but it's just it's a perception primarily because of the training, a lot of advanced training, and really putting the time in. I am the current author of the California DUI Defense book. It's the edition that's coming out this year. It'll have my name actually as the lead author in it. It's a book I was asked to edit a few years ago, and I've been grinding away for the last several years to try to get it into updated. It's a book that was really out of date, and I would say that it's getting close now with this new edition. It's supposed to come out, I think, in September. In there, obviously, there's chapters on DMV and whatnot. I've probably done, I don't know, a couple thousand DMV hearings. It's something that's definitely part of my practice, important part of my practice. And I'm a board member for the California DUI Lawyers Association. And, that's it.
All right, great. And how many DUI jury trials have you done?
Probably somewhere between 100 and 150. I mean, overall, I've done over 150 trials, jury trials, because of the you know, the implications in a DUI case are not as severe. It's a lot easier to get those cases out to trial. So I mean, there's times when I would be trying. I mean, last year I tried 6 cases in about a 9-week period of time. So I mean, sometimes you crank them out, man.
Yeah. Okay, great. So we're going to have Panagiotis start off, and why don't you take it away, Mr. Prountzos?
Cool. So I'm going to start off with just the steps of a DMV hearing. And basically, I'll start from the beginning. So the client comes in and they've been arrested for a DUI. And so the first thing you actually ask is whether or not they've requested a DMV hearing. Because as well, the DMV, from the date of arrest, you have 10 days to request a DMV hearing. If you do not request a DMV hearing within those 10 days, you lose your right to hearing and your license will get suspended after 30 days. So that's the most important thing to ask, whether or not they've requested a hearing. And if they have not, immediately I would fax the DMV, the driver safety office, and I would also send a letter to be sure, then call the next day to make sure that they've received that request. Because again, if you, within 10 days, if you don't get it within 10 days, you lose the right to hearing. And there is a way you can request in writing if there's any emergency reasons as to why a request wasn't made, if they're in the hospital or something like that. But what's crucial is within the first 10 days to make sure that the client gets to get a request in to the DMV. Sometimes clients do it themselves, which is just fine. And if they do that, you could go in and so the DMV hearings could be in person or over the phone. So if they requested it themselves and they've done it in phone and you would rather do it in person or vice versa, you can call and change that. But again, the most important thing is within those first 10 days to get the hearing, to request the DMV hearing, because you don't want to lose that right. And then after that, the DMV will send you evidence. So the DMV's evidence will be, the DMV will send you the incident report, a DS-367 report. They will send you the chemical test, so they will send you some evidence too, so you can get started on it. And that's where you will be able to narrow down the issues. So in a DMV hearing, it's limited to 5 issues. The first 3 issues are whether or not the officer had probable cause to stop the driver's vehicle. Did the officer lawfully arrest the driver? And was the driver operating a motor vehicle with 0.08% or more by weight of alcohol? And there's another 2, if it's a refusal hearing, and that is, was the driver told that a refusal to submit to or failure to complete a chemical test would result in a 1-year license suspension? Or did the driver refuse to submit to or fail to complete a blood or breath test after being asked to do so by an officer? So again, these hearings are pretty much limited to those 5 issues. So once you start getting the discovery in from the DMV, you could start formulating the argument you're going to have with them at the hearing. So what I like to do what I've learned to do, and Peter's book has been excellent. I've used Peter's book since the moment I've been practicing, and that's always been kind of like my Bible. And in that, I remember when I started practicing about doing briefs. And briefs to me are a great way, because when you're getting ready for your DMV hearing, they're limited to those 5 issues. And so when you're getting ready for your argument, you're writing them out anyways. And I realized after looking at that book was, if you put this in brief form and submit it, it's number 1, it's a great way to really get your argument in order. And number 2, if you submit it to the DMV hearing officer prior to the hearing, it's a chance for them to actually see what you're going to argue, and it's a way to kind of baby them into what you're going to argue at the hearing. I'm sure Peter will go into this as well. These DMV hearing officers, they're not lawyers. Most of them aren't lawyers. And so DMV hearings could get pretty complex in issues. So it's a great way to guide them through your argument before you even start. So what I was hoping to do was share my screen and show you what a brief looks like. So here we are. And so my apologies if I rush through the issues again. So there's 5 issues in which DMV hearings that you're attacking in a DMV hearing. In this case right here, what you're saying is this was whether or not the driver was told that if he or she were to refuse the chemical test, if she were to refuse a chemical test, whether her license would be suspended for 1 year. So basically, the PAS tests before arrest, those are usually voluntary unless you're on probation for a prior. But for argument's sake, let's say that you're not on probation, it's a first-time DUI. The first test, the PAS test you take prior to arrest, that's optional. But after arrest, you have to submit to either a blood or breath test or a urine test. If you don't do that, by implied consent, your license will be suspended for a whole year if you do not submit to that test. So the officers have to clearly instruct you that refusal of this test will result in 1 year. Now, in this case, what happened was the officer was not clear about a 1 year refusal. He kind of danced around the issue. He did not read the admonition correctly. And he told her permissively, it might get suspended. So this was when I looked at this issue, I think, all right, great. She was never clearly told that her license would be suspended for a year. But if you looked at the evidence in this case, the body cam, I mean, there's a lot of verbiage going back and forth between the officer and the licensee, and it got a little confusing. So I thought a brief in this case was perfect because, as you'll see on the second page, we'll walk through it real quick. I was able to sneak in basically a transcript of what was going on between the officer and the licensee. And again, at the hearing itself, I didn't use live testimony from the officer, rather we used the body cam, but I didn't want the language to get lost on the hearing officer. So I thought it was crucial that she was able to read through it to see that there was no clear statement from the officer saying that her license would be suspended within a year. I thought this was a really powerful tool in getting the license set aside because walking in there and through the hearing, she had already seen this. And when we then watched the video, she had sort of a reference and guide to what to look for. So I thought it was a really good tool. And you'll see what the briefs look like. I mean, it's just kind of like any other brief. On the first page, on the left side, you put the matter, the driver's license, and whatnot. And then it's almost like an IRAC, really. The first, you put the issue, you set the rule out, and then just analyze it. And it's a great tool to get you ready to prep for your hearing, to give the hearing officers a really good window of what you're arguing, and it's also great to set a record as well, which I'm sure Peter would agree with. That if there's any extra action to this, you put this in the record and you're clear. So yeah, so let me get out of this window. The other issue that I think is of the utmost importance when having a DMV hearing. So my office is in San Francisco, and I'm really close to the DMV hearing offices. I used to do a lot of DMV hearings by telephone, and it was a great effective method, but hearings by telephone can be rather quick and impersonal with the hearing officer. Once I started taking all my DMV hearings in person, especially at the San Francisco office, it was great to actually build relationships with the hearing officers. Like I said, they're not lawyers. But when you go in there, bring them briefs and get FaceTime with them and treat them with respect and actually build a reputation with them, I feel that it's gone a long way. And when they know that you're handling the hearing, you're going to be handling the hearing with knowledge of the law and with respect to them, which I do feel has been very appreciated. So I always advocate for doing in-person hearings. Get to know the hearing officers, and they get to respect your work, and they take your work much more seriously. Peter, if you'd like to interject there.
All right, so on the subject of in-person hearings?
Yeah.
Okay, so obviously there's a big issue now because we don't know if we're gonna have, when we're gonna have in-person hearings again.
Yeah.
I'm advocating like heck for the DMV to, every time I talk to a hearing officer, I said, hey, put some heat on these guys to get video conferencing for these hearings because, it's really important to be able to build that relationship and be able to present your evidence and whatnot, and doing it by phone is obviously something very difficult to do. So I guess Panagiotis went away, so now it's me. So I'm going to go through this the way I think about DMV in my practice. So there's a couple of considerations. Okay, so one thing is, what's the purpose, of the DMV hearing? That's really important. Is it really about winning the DMV hearing? That's a very important question because you got to look at it kind of in the big picture of how you're representing your client. And you may not, the goal might not be, I want to win this DMV hearing, because what happens is obviously that you have the consequences in court. So let's say on a first DUI, you're doing the DMV hearing and you win your DMV hearing, but turn around and plead the guy in court, or the guy loses the trial. Well, you're going to have the same consequences. So it's not really going to matter the fact that you won your DMV hearing. Nobody's going to be persuaded by it. Nobody's going to be, moved in the court generally that the fact that you won a DMV hearing. However, you can gain a lot of information and valuable information during the course of a DMV hearing. Now, obviously, there's opportunities to win DMV hearing. You gotta win them, and I'm not suggesting throwing the DMV hearing. I'm suggesting trying to win the DMV hearing, but maybe you don't want to close the hearing out and put it to finality and leave it to the hearing officer to make a determination. The way you do that, obviously, is you have to engage in a process of discovery and bringing witnesses in and things of that nature. Okay, so initially, the purpose of the DMV hearing, has to be understood. If you have a client, say that is a commercial driver, the losing the DMV hearing is going to have the same impact as losing the DUI case. It's going to cost him his career for a year. And so obviously you got to do everything you can not to lose that DMV hearing. So one of the things you can do is try to have that hearing trail along so that you resolve your court case prior to the DMV being resolved. That's really important. There's obviously other scenarios where that would be the case. The issue is, DMV, you may have license consequences. Those license consequences that you would only suffer because of the fact of a ruling at the DMV, your client would only suffer those. So you could actually, complete a DMV hearing, lose that, and have your client suffer those license consequences, and then turn around and win your case. Yeah, it'll get rid of the administrative prior, but at the same time, the client has already suffered those license consequences. So you really have to take a look at what is the purpose of the DMV hearing. All right, now, as far as DMV, just generally, how I handle it is, I think of it as it's just part of the universe. The DMV offices, the hearing officers, the whole process is part of the universe of my, that part of my practice, practicing DUI defense. And so, everything I do, everything along the way is about educating the hearing officers, building relationships with those hearing officers. I'm going to see them again. I'm going to see them on a different case. I'm going to see them with the same type of issues. So, if you're going to be doing a number of DMV cases, DUI cases, then, you got to think about it as kind of building, your rapport and relationships and your, just the manner in which you kind of control these proceedings. It's going to be much more difficult if we're doing everything on the phone, obviously, but, because I have done virtually all my DMV hearings in person since I've been practicing, with the exception being that it would be that, for example, we're just calling in to let the hearing officer put their case on and then reconvene for my hearing. we're just doing something like that, or just getting a date or whatever the case is, not to actually do anything substantive. It's very rare where I will do something substantive over the phone. The other exception might be I've already wrapped up the criminal case, and so now it's just a pro forma thing getting the DMV hearing done. But other than that, I do them all in person. And so right now, it's a struggle having to deal with our current situation, because it is taken, I think, takes a lot away from your advantage of building these relationships. I mean, I'll go to the DMV hearing office, and even on a day when I know it's a short hearing or something's going to be a kind of a pro forma thing, and I'll just sit down and BS with the hearing officer, for 30 minutes about our family. I got every one of them asking me for legal advice. I mean, that's the kind of thing you want to do, because you're not dealing with lawyers. You're dealing with people. You're dealing with them face to face, and it's essentially a private situation. It is recorded, and so you probably have to be a little careful about being too loose about what you have to say, but you can engage in a lot of conversations of a personal nature that has nothing to do with the case and build that rapport. It's absolutely imperative to do that. One of the things it helps me do is, I can tell you, I hear from attorneys all the time that they have difficulty with continuing hearings. I have absolutely no difficulty with getting continuances on hearings last minute, whatever. I give them whatever notice I can as soon as I can, but over and over and over, I'm not able to do that. And I do not get resistance in that regard. I never take it for granted. You never take it for granted that it's going to happen. Jen in my office, does a lot of my scheduling stuff, and I always tell her, I need to get it continued. She thinks sometimes you could just call and get that done. I tell her, you never take it for granted. So you make sure you do everything, with communication, with, they want a fax, you get them a fax, as much notice as you can. You provide them with a legitimate excuse. You do everything you can. You never take it for granted. I don't care if I've got 1,000 continuances granted. I'm never going to take it for granted that the next one's going to get granted, because when it doesn't, you're going to be burned. So, you got to come prepared at all times. All right. Now, with regard to the actual hearing, before I ever get to the hearing, usually I will engage in quite a bit of discovery. And so I will use that subpoena process at DMV really to take advantage of a lot of avenues for discovery that may give you a one-up even on the DA's office, because there's discovery you could obtain with those subpoenas through the DMV process that that the DA doesn't even bother to engage in. And you're going into suppression motions, your plea bargaining cases, you're going to trial, and you're holding evidence that the DA doesn't have. And there's no obligation for you to turn that stuff over. It's all stuff you've obtained generally from law enforcement. And so, it gives you an advantage. So you might as well use that. One of the primary purposes for a DMV hearing should be preparation for a suppression motion. You get a free shot at the officer. So you want to get officer subpoenaed in there. I used to argue or say advise that you should have an officer subpoenaed on every case. You should subpoena the officer. I'm kind of a little hesitant. I'm still going down that road, but I'm rethinking that right now because of the fact of the availability of video. And, some of the things you were trying to accomplish by having the officer there, you don't necessarily need with the video. But at the same time, having the officer there is very, very important, because there's a couple reasons. One, you can win a DMV hearing just on the fact that the officer is not cooperative as a witness. So these officers, a lot of them are trained. First of all, it's a big pain for them to come down to DMV. Do not agree for them to appear in person. Now we have to, right now, this little window of COVID time. But short of that, don't agree to have them appear on the phone. Make them be there. They don't want to be there. If they don't want to be there, they're not going to be a witness who is forthcoming. Now, the officers have been taught. It's incredible, but it's been taught. They've been taught that they only have to be there for some limited purposes, and which is not true. It isn't true. And so they'll be resistant to answer questions. So for example, if you go into field sobriety tests or you go into issues related to the detention and arrest, the officer may be resistant. And some officers will say, I'm not going to answer those questions. I've been told I don't have to. I'm not going to do that. And then you kind of have to turn it over to the hearing officer, and the hearing officer is usually going to back you up on that. There's some hearing officers, obviously, that just don't get it, but most hearing officers are going to okay, the questions I'm going to have to ask later, they pop up and it distracts me, so I'm going to do it later. But anyway, the officer, if he's resistant, the hearing officer then can advise the person and that they're required to answer the question. And if they still don't do it, you're going to win that hearing. Okay, that all you got to do at that point is come up with some significance and relate it back to those issues that Panagiotis was talking about, and you're going to win that hearing. I've done that many, many times, and so it's something, one way when you got nothing else, it's a way to try to win the hearing. Additionally, with the importance of admonishments, it's really important to get a shot at the officer in a DMV hearing before he's being coached by the DA, protected by the judge, and all that. Let's get an informal setting. They're more apt to say they're not really prepared. They're more apt to say they don't recall things, instead of trying to come up with stuff that's baloney based on their normal procedures. So there's really an advantage where you actually get more honesty out of the police officer at a DMV hearing than you're going to get in a courtroom. The admonishment with regard to blood tests is really important, and the admonishment regarding the officer carrying out his duties regarding the breath test as far as the 15-minute observation period. So let me just go through a couple of those issues. So what I'll do is I'll go back for a second and just tell you how I pretty much handle a hearing, and then we'll go into breath and blood. So the way I generally will handle a hearing is I'll allow the hearing officer to put her exhibits on, and then I'll state my objections. Now, sometimes I will not state my objections. I will, if there's a witness that is waiting at that particular hearing, whether it's the police officer or whether they brought in a witness or whether it's an expert that I've brought in, I'll ask not to do the objections right then and there. You got to make a note to make sure you don't forget that you didn't make your objections. But I think it's important because once the record is complete, if they haven't overcome the objection, you're in a better position to argue, because what will happen is if you make your objections before witnesses go on, is they'll now correct those deficiencies in their records, which they might not have recognized. Another thing is with regard to the actual record of the DMV hearing officer, do not take for granted, and this is one of the reasons why I really can't stand phone hearings. Do not take for granted, one, that the records that she's producing are an original record, okay? And two, do not take for granted that it's a complete record. So the DMV, they get their evidence in from the officer. Sometimes they'll request additional evidence, and they have an administrative record, and that administrative record is reviewed and for its adequacy. And then they, go forward with their hearing. Well, the hearing officers will oftentimes, and it happens a lot, is they will not include certain records in their administrative record. They won't put them on as exhibits. And by and large, if they're not doing it, there's a reason. There is a problem with the record. So you always ask the hearing officer to see the complete record. Some are resistant. However, you are entitled to see the complete record. They cannot withhold records from you. So you should look at the one at the originals, and two at the complete record. So an example would be maybe they rely on a breath card that has the check mark that the 15 minutes was observed, or the times are in, or something like that. And then they have a separate thing like the printout itself where it's not done, or they're relying on the DS-367 saying Title 17 was followed, but in reality, we see a precautionary checklist that doesn't indicate that that's the case, or there's some inconsistency with the records. The fact that a record is a cut and paste record as far as the probable cause on the DS-367. You should always look at the originals because of all the documents, because there's different color ink, you know, there's crossouts, there's funky things going on with the record. So take a good look at it. It's a really good practice. There's little nuggets of gold there from time to time. So once the officer, hearing officer, puts on their marks their exhibits, then if a witness is going to come on, I bring in the witness. So let's talk about a breath case for a minute. So a breath case is one of the primary things you want to do in a breath case at DMV, and it's gonna help you in trial as well. Okay, is you have to build a tight timeline. The timeline is critical. You need to get CAD records. You need to get, and it's the dispatch records. You need to get any kind of records you can get from the jail, any kind of records you can get, booking records, anything you can get your hands on, and build a tight timeline. Because we know that in order for a test to be valid, at least at the administrative level, is that it requires that there be a continuous 15-minute observation period prior to blowing into the breath machine. And it is not difficult to disrupt that timeline. It requires continuous observation. It is not unusual at all for officers to come in, bring somebody in and stick them in a room and come back. It's not unusual for them to walk out of the room. And those are things you got to explore. And, if you build your timeline and there's gaps in your timeline as far as, let's say there's 20 minutes and you have nothing to fill that. Well, then you need to bring witnesses in and you need to attack that timeline through the witnesses. If they can't recall, that is helpful, but it's more helpful if they actually can recall or if they did something else. And the only way you could do that is if you will have superior information because you've gone through and you've pulled those records that build that timeline, and the officer, he's just going off of, 90% of the time they don't even remember the fact that, how the 15 minutes was actually conducted. They just take it for granted that it was done based on looking at their cursory look of their report prior to testifying. So one of the most critical things to do at a DMV hearing is to shift the burden to the DMV. That's the winning formula for a DMV hearing, is the shifting of the burden. So at the outset, the DMV has a very easy burden to meet. Basically, what they need to do is they just introduce their records. Their records come in through various hearsay exceptions. And then what you need to do is object to the foundation, to these various elements of these hearsay objections. But with the public records exception and whatnot, they have a pretty easy chore, okay? And even in cases where there's clear deficiencies in the record, in other words, the 4 or 5 documents that the hearing officer has, even in those instances where I review it and I know I have a winning DMV hearing based on that issue, I don't, first of all, take it for granted that the hearing officer is going to go along with that. Number one. Number two, it doesn't bother me to say, okay, I'm going to bring the officer in anyway, even though the likelihood is that officer may correct that deficiency, if my goal is bigger than winning that DMV hearing. If it's more important for the client that I need to build a record that's going to help me go to trial on this case or win a motion to suppress on this case, then, you got to weigh the benefits of, a quick and easy win at the DMV. The fact that you tell your client, oh, I won the DMV, and you think you did something for him, great, you get that moment, but the reality of it is that that's not really, in my view, helping the client. The client, you got to look at the big picture, the whole case. So you really got to take a look at it. Okay, so you can't be afraid, is what I'm saying here, is to bring witnesses in, even though you may have a DMV record that you could have a sound objection on. The hearing officer also could reconvene the hearing in order to try to correct that deficiency. I will say this: the Panagiotis talked about the brief. The brief is important from this respect. If you have a deficiency in the record and you bring it to the attention of the hearing officer through a brief, or even a simple thing like a written objection, prior to the hearing. And then you get to the hearing and you make the objection. And the hearing officer now realizes, oh, somebody missed something here. Your argument is that, first of all, they went through the administrative review. They thought they had an adequate record. They clearly didn't. You gave them notice of the fact that this deficiency existed, and now they want to reconvene the hearing. You have an extremely strong argument that there's not cause to reconvene that hearing if you've taken the steps of alerting them with a written brief or a objection. Now, using briefs, I don't always use briefs. Matter of fact, in large part, I don't. I do use briefs when I really think it's important to do something like I just talked about, or to do something else that, it's complicated or convoluted or something like that, and I really want to hone the hearing officer in on it. But I don't always use briefs, I have to say. But it is a good practice, not even a question. The next thing is, so with regard, let me just talk about the breath test real quick. So with regard to winning a hearing with the breath test, again, the most important thing is to set up that record. You want to establish that there's not a continuous observation. You want to get the records from the procedures for the lab. The lab actually has in their procedures, the fact that the observation period, how it's supposed to be conducted, that type of thing. And some lab records, some lab procedures are pretty good about it. For example, in Contra Costa County, their procedures, and I'm not sure if the current procedures say it or not, I'm thinking right now, but their procedures historically have said that it's not in the best interest to do it while the person's in the car. It should be done in the room when they're there with the individual at the station. And in fact, historically, Contra Costa County actually tried to do a forced observation with the machine. They tried to program the machine, which can be done. Draeger has the ability to do it, and I know Contra Costa is not Draeger anymore. But I at one point got the memos going back and forth. And what they wanted to do was say the officer had to, press the button at the beginning of the 15-minute observation period and had to, continue to do so, kind of like you're watching a video, for credit online, and it pops you back and says, just so you're still there. And then at the end of 15 minutes, mark that 15 minutes occurred. And so that would mean it would have to have occurred in the station and all that. But what happened is they received a lot of resistance from law enforcement on that, and they ended up not implementing that. They withdrew that request of Draeger. But that's really important, because what it highlights is the fact that police officers do not want to do that. They're in a hurry. They don't really see the importance of it. And so they're not going to do it. So it's a very rare situation where you have a person who actually sat down, in a room with somebody and waited at least 15 minutes before doing the breath test. So what you accomplish by establishing that is this burden shifting that happens. So in other words, now you've established as a Title 17 violation. By establishing a Title 17 violation, that you as the defense, the licensee, has come forward with affirmative evidence to show that there's some deficiency in the evidence. Now, previously, DMV goes through cycles, and it gets worse over time. But previously, if you could identify a violation of Title 17, like a 15-minute observation period, you could walk out. You can count on walking out of there with a win. Can't do that anymore. You can't count on that. That gets your foot in the door, but you need to still bring an expert in to put on evidence that in fact that why that 15-minute observation period is so critical, and that how these machines are not capable of ensuring that you have a valid sample, and that one of the safety measures that's absolutely critical is this compliance with Title 17. What I always stress to the hearing officers, and I think it resonates over the years, is that the Title 17 is an administrative regulation, and the DMV is an administrative agency, and their whole duty is to enforce administrative regulations. And so, I argue to them that this has a greater force and effect, even than it does in court, because, of their duty. And, I really feel like that's resonated with hearing officers over the years. One of the things I really try to do, and because I know I'm coming back to these hearing officers, is I really try to educate the hearing officers. I really try to educate them on the science. I really try to educate them on the law. I take the time to make sure I do that. You know, if you're coming back, if you're going to be facing, dealing with these people again, you may be able to convince them over time, you know, even though they are, you know, oriented or, you know, they come up thinking a certain way, you know, you can change that over time. There's no question. Now, there is certain hearing officers you just can't. You know, if you're faced with a situation where you have a hearing officer that you can't, then you do have the ability to request a different hearing officer. It's not always going to get granted. You have to give your reasons for it, you know, unfairness, bias, personal relationship, whatever the case may be. And oftentimes, you know, it will get granted. I will say though, as a caveat, I just got a call yesterday that, you know, a hearing officer, Ms. Pandea, who I had asked to have her removed from a case, and she was like, yeah, go for it. I have no problem. I won't object to that. But Ms. Carr denied my request. So now I got to reschedule with Ms. Pandea. So now what I'll do is I'll go back and I'll build a nice record to show what the problem is with Ms. Pandea. And you know, if I lose that hearing, which with Ms. Pandea, there's a really good chance that's going to happen, then I will, now I've said she can't be fair, and I will demonstrate through the hearing that she can't be fair. And then I'll have a nice record for administrative review and for a writ if we got to go down that road. So with regard to a breath test, you know, that's the most critical thing, the observation. With regard to a blood test, the way you shift, and I'm shifting gears real quick here because it's 12:48, is that, you know, in order to shift that burden, there's a couple ways to do that. So one of the things you need to do is you need to obtain the chromatograms. You need to obtain the underlying foundational scientific records from the lab. You can get those through DMV. You don't have to wait for a case to be filed. You don't have to do that through court. You can make that request, and you know, they'll produce them. You get them at DMV. If you do that, then you bring an expert in. The expert then is in a position to you know, opine that there is some problem with the blood test in order to shift that burden. So like the breath test, the timeline on a blood test is really important. The reason the timeline is important is when you get the chain of custody records, you know, you get the test results and all that, well, then it shows that there's delays. Anytime there's delays, we're handling biological evidence. It opens the door that there's some kind of change in the integrity. With regard to blood testing, the most important thing, whether you're in court or at a DMV, is 1219 of the Title 17. And that deals with the fact that it is, they're required to retain the identity and integrity of the blood specimen from collection through handling and storage all the way to reporting the result. It pairs up perfectly in court with the circumstantial evidence instruction. It's like your guide through trial, but at DMV it serves the same purpose. Even more so because shifting that burden with Title 17 is what allows you to win the hearing. So, you know, in order to do that, you need to obtain show what happened with this specimen, show that there may be, you know, some problems associated with the analysis, and, you know, give your expert an opportunity to do that. What DMV hearing officers are doing now is, because they got tired of getting beat up on this issue, is they're now bringing their own witnesses in. So now what do? You get not only the shot at the officer at DMV, but now they're bringing their witness in, and now you get a free shot at that witness. You know, if you're going to take this case to trial, you're getting a free deposition on this witness at the DMV proceeding. You know, and you can start laying the groundwork for that. You know, this is a strategy. It's how do you use this to your advantage? One of the things that you know, in questioning officers and questioning these witnesses, you have to be concerned, and even, you know, just any kind of pretrial proceeding where you're engaged in questioning. So whether it's DMV or whether it's like a suppression motion, you know, suppression motion, obviously you're trying to win that, you know, regardless. The DMV, like, again, you're not necessarily the end goal. You're trying to win it, but it's not the end goal, and it doesn't have to be done now. Okay, but the how far you go with a witness, you know, you have to think big picture. You know, do I really need to go through in detail with this officer field sobriety test at a DMV hearing or at a suppression motion. I mean, it's a rare occurrence that you'll win a suppression motion based on, you know, problems with how the officer administered field sobriety test or something like that. It will play a little more weight at DMV, but you're not going to win a DMV hearing for that. So the question is, do you really want to go into that kind of detail and alert the officer to the issues which you may now want to beat up on them in front of a jury for the first time? So you got to weigh that. Sometimes you can do that because you can create a really good record on a point at the DMV hearing, and then, you know, he's stuck with it. If he goes to trial, now he tries to change it, well, you know, then he's basically admitting an error, and you can bring that out. So it's just a situation. It's very specific to the facts of the case. It's a whole strategy. You know, a DMV hearing is not something that should be really simple process. It's really just an investigation, you know, one aspect of your investigation as you're trying to direct this case to trial, to try to win this trial. And really, I mean, honestly, you should be going into every case, like right from the beginning. You're building that case, you're heading down a trajectory to trial. And you know what? It's up to them. It's up to the prosecution to stop you. And the only way they're going to stop you is they're going to give you what you want. And you just keep going down that trajectory, and you get yourself in a position to try these cases. And these are critical cases to try, because the punishment is so low, and, you know, it builds you for all bigger cases. You know, the issues, there's all the issues in dealing with science and all that. And you know, you learn it here at DMV, you learn it in the lower level misdemeanors, and it takes you forward into both these cases. And then if you start doing civil cases, you go into civil cases, and all this experience you had questioning these officers, questioning experts at a DMV hearing, you know, and doing it in court, you know, it just gives you so much more experience than the average civil attorney who's only come up through that avenue. And so I just can't emphasize enough how, for you personally, how this is important to your practice, but even more so importantly for your client in the context of handling a DUI case, how it's really important to engage in all this at a DMV hearing. So I'm going to leave some time on the table. There's a whole 7 minutes according to this record. I don't know how far we're going to go, but I'll step back for a minute, Ms. Wolf or Joe.
Okay. And we have a lot of good questions in the chat, so maybe we'll start off and have Panagiotis answer some of these. So let me do the first one from Miss Kiana Washington. The DMV is giving us the worst time on getting an in-person hearing right now. So that's one. And then the second question is from Ashley Bargain Quest. Will you have any advice about how much legalese to use in these briefs, since the hearing officers are not judges or lawyers?
I'll take the question from Ashley. So, you know, that's something I've danced around with a lot. And again, these hearing officers aren't lawyers. Since they aren't lawyers, you know, in my briefs, you'll see in the brief I provide, I throw in case law. I really, there is legalese in there, but I try my hardest to walk them through with the least legalese outside of the case law, you know, and I think that's the most helpful, because it gets their mind going to the issues at hand, but without going over the top, because, you know, lots of these issues can get really complex. You know, there's science that gets involved, like as Peter was talking about, you know, so I try to break it down as common as possible outside of legalese when I'm writing the briefs, because, you know, it's my first crack at the hearing officer, and I want the hearing officer to really understand what I'm going to attack with my oral argument when I'm at the DMV hearing. Peter?
So if you have a case on point, you're going to be citing your case at some time during the proceeding, whether it's in the brief, in the hearing, or in your administrative review request, which I would encourage people to do, or if you end up filing a writ afterwards. If you do not have a case on point, then it's not necessarily a big advantage to get into a legal argument. So in that circumstance, you might not put the legalese. Another issue you have to look at is think about the record. You know, do you want to lay your chips on the table, even if you have a case on point in the brief, if they can correct it easily? And so if they can correct it easily, then you got to be a little guarded on that. But you know, again, it's a case by case. There's no particular, manner in which to do it. You look at the overall strategy of it. Okay. I'll take the next one from Ms. Washington. It says, what is the authority require a telephonic hearing? I don't remember the exact site. The current authority, and which is really what is important, is the rules that are the orders, the emergency orders that are out there. And honestly, I haven't looked at the most recent order. The last order, though, was pretty clear, and it came out. It was not the initial order, and it came out and said that basically for this purpose, that administrative hearings, that there was no mandatory requirement for an in-person hearing, and that telephonic hearings could occur. So that would be the controlling order at this point. I would say look very closely at the emergency orders right now and see whether or not that is something that is mandatory right now. If it's not, then you make the argument. There's absolutely no reason they can't do it because out of convenience to them or anything else. There has to be some legal authority for it. So I would look at it. Other than that, there is no authority. The authority is the other way. The authority is that you have a right to an in-person hearing, and then you have a right when you're doing an in-person hearing. This is an important point, to request an in-person hearing at the outset, because if you engage in a telephonic hearing, you give the officer the opportunity to engage as well. You have no reasonable objection. However, if you're doing an in-person hearing, then the officer is going to be required to appear in person as well. Okay, go ahead, Panagiotis, handle the next one.
So I'm looking at a question. What is the basis for reconvening the DMV hearing? Can the driver do this? And you mentioned stating a hearing. Okay. So in my experience, I get a lot of reconvening when I bring in experts. And my hearing officers, I've just had this misfortune where I bring them on, they cross them, and they will reconvene for a purpose to look over, to analyze, I guess, what the experts brought in. So I see a lot of reconvening on that. And I personally have not asked for a reconvene. Have you, Peter?
All the time.
All the time?
Yeah.
And why is that?
So a couple of reasons. One is that rather than wearing them out, asking them for continuances,
Gotcha.
okay, you can, sometimes and this again, it's cyclical at DMV. So it used to be that they wanted to start their hearing within a certain period of time. So they wanted a record that they had started their hearing, so they would agree to a continuance if they would be able to put on their record and reconvene. Now what's happening is they're having to finish their hearing by a certain time. So because they're having to finish their hearing by a certain time, they don't have a problem starting it later, okay? Because it's not by a certain date, it's by a certain date after it's been started. Okay, and now there's an interesting thing going on. I'm recognizing at DMV, and I haven't asked the hearing officer directly this, but I see it happening, is that they have like let's say there's a 90-day window for them to complete a hearing. They don't have a problem with, not starting the hearing and kicking it into that second 90-day window so that they now give you another 90 days to do it. And I'm just throwing 90 days out there. I don't know what the actual time frame is, but the idea is another time period. So, that is one of the reasons for reconvening. Another thing is you just, here it says, what's the question? The question is, okay, the third party question. So let me just answer that real quick. So first of all, a third party would be like a witness for driving or something like that. So the law is that they can use, hearsay at a DMV. It's a lesser standard than normal and all that kind of thing. However, they can't establish probable cause through multiple hearsay. Okay, that's the law. And so they try to do it, and they'll do it. And if you don't contest it, they're going to do it. So can they do it? Yeah, of course they'll do anything they want to do. Is it legal? No. If the question's probable cause, and the case law is right on point, that it requires that they have some exception to the hearsay rule. Now, can they reconvene? What the case law has said in the past is that if something is brought up by the driver at the hearing, then they would have a legitimate basis for reconvening. So that's getting back to kind of the notice that you're giving them by issuing some sort of brief. You are putting them on notice of that problem. Now, obviously, when you put them on notice of that problem, then that gives them an opportunity to correct it before the hearing. So, you know, you have to weigh that. But if you come to the hearing and all you're doing is making objections, that's not a basis for saying that, you know, they didn't have sufficient evidence and they need, you know, you didn't raise something new, you base it on that evidence. It's only when it's facts that are brought in. So if you bring an expert in, if you have your client testify, which I never, ever do, you know, it'll happen someday. Maybe it's happened, I don't even remember, but it's something I just don't do. But anything you put on evidence is new evidence. So think about if you're putting on records, if you're putting on witnesses, you're opening the door to the possibility of them curing a problem where they're relying on multiple hearsay from a third-party witness. So I hope that answers your question, Kiana.
I think that handles all those. Now, Peter, I want to ask you something, actually. I think it'll help everyone else out here. What are some of the most important cases you think we should have at hand for the DM, just in our back pocket that, you know?
Yeah. Okay. So one is Glatman versus Valverde. Okay. Glatman versus Valverde is important because, you know, a DMV will typically introduce the DS-367. The DS-367 will typically be insufficient. And if it's insufficient, then they are going to want to rely on a police report. So what the Glatman case is, and I forget, I think it comes from Melendez is the other case that it relies on, that basically that the officer, in order for the hearsay to survive a foundation objection, it has to be something that was created at or near the time of events. So, you know, I think that case, I believe, is a 2-day case. In other words, where you have an arrest and you have a report that's dated more than 2 days later, then there has to be some kind of record of the fact that this information was noted or recorded in some way and then transferred into the report, such that, you know, the delay of memory and recollection and things like that did not play an effect on the reliability or trustworthiness of that information. And so that's a critical case. Rose versus DMV, and so the application, I'll just give you a quickie on that. The application of that is this. You have an undated police report. Undated police report, we don't know when it was created. If we don't know when it was created, we don't know that it was done at or near the time of events. Therefore, if the DS-367 is insufficient, they cannot cure you know, the record with the police report that's not admissible. They'll oftentimes let it in anyway. However, often they don't let it in if they can't establish, you know, if it's an undated report. If you're talking about a 2-day, 3-day, 4-day, 5-day thing, they're more likely to let it in. But you know, it creates a record even in that situation. But also in that record, I'd raise it because the case law very clearly says 2 days. Another case is Rose versus DMV. Rose versus DMV is a case that has to do with breath testing. And Rose versus DMV is one that lays out really nicely the shifting of the burdens at DMV. And in that case, there was a lack of 15-minute observation period. They brought a witness in to show that that was the case. They shifted the burden back to DMV. DMV didn't put on any further evidence. Therefore, the court upheld the ruling, and the appellate court. So the writ was one, and then the appellate court upheld that. McDonald v. Gutierrez is a case where the DMV attempted to, you know, well, actually, the facts I might not have exactly correct. What it stands for is this. It stands for the fact that it only comes in, the police report, to cure what are called minor omissions. So in other words, you can't establish probable cause by using something like a police report. You know, anything outside of the sworn statement. The sworn statement is supposed to include, so the DS-367 with the probable cause statement is supposed to include all or nearly all the facts that are required to meet those various elements that Panagiotis set out. Okay, so if they don't have that and they're looking at a police report now for a third-party statement, for example, Ms. Washington, then you argue that, you know, they can't use that for the purpose of supplanting the information contained in the DS-367. The officer hasn't carried out his duties. It's you know, part of the public record exception is if the officer performs his duties in putting all or nearly all the information. That's in 13380, I think it is, of the vehicle code. And you know, if he fails to do that, you can't cure it by supplanting a fact that's critical to the issue of probable cause based on some statement that's outside of that sworn statement. That's another one. Obviously, there's a number of them. Just off the top of my head, I think, but go ahead.
And with that, I mean, from when I started doing this, one of the first things I do is I'll take every date and every time and highlight them right when I get the paperwork, because the amount of inconsistencies you do find in these you'll find them. You will find them. So it's important to not overlook any sort of time or date anywhere, because that, you know, the devil's in the detail in a lot of these hearings and a lot of the paperwork that you get back. So one of the things, again, what I do is I will always highlight and look at the times, make sure everything matches up for the 15 minutes, for whatever it may be. It's important to really, really keep a note on that.
Yeah, absolutely. I mean, that's a really good practice, no doubt about it. You know. So.
And then also, you guys, one thing that I do want to add is whatever you fax to the DMV or mail to DMV, follow up with them. Make sure that they got it. There's been a lot of hearings that I've gone to where I don't follow up and you think they have, and they say they never had it. So it's really easy. You call the operator after you've sent it a day or two later. They'll know if it's in or not, and always make sure to double up on that, because it's happened to me a lot.
Let me follow up on your late hearing request thing that you described earlier.
Sure.
So there is a provision for making a late hearing. If you have cause, you should be able to get a late hearing. If you're in a trouble where you maybe don't have cause, one of the things that you can ask for, if you think it's a situation where they're probably not going to give you the hearing, you can do a trade-off. The trade-off is that they go ahead and they leave the suspension in place, but they give you the right to the hearing anyway. So in other words, you just don't get to stay. Now, what's the benefit of that? The benefit of that is that, yeah, okay, the client then suffered that suspension, but you still may be able to set aside, you know, if let's say you lose that hearing, or excuse me, let's say you win the hearing because you preserved the hearing, but you know they had that suspension. But let's say you go to court and now you are getting a disposition that's not going to result in a conviction. Well, now you don't have the administrative prior, you know, that's on the guy's record. So that would be a benefit of that. Plus, if you don't request a hearing, you're going to lose out in all those aspects of your investigation that we just kind of went over. So, and then I will always try to submit a declaration from my client as part of that hearing request. If it's a really crappy hearing request, late hearing request, I maybe not do that. But if I have something legitimate, like he called the 800 number, the 916 number, or he went to a DMV hearing office or a DMV office and he was told that, then I'll tell him, hey, go back to the office, get the person's name, let's come back, get a declaration. Yeah, they told you it's useless. Well, they're wrong. And get that declaration put together, and you're going to get that late hearing. So don't give up on the whole late hearing thing. Okay?
Cool. And then I think if there's one last important thing to go over, this happens a lot, holiday weekends, people come into California to get a DUI, but they're not from the state of California. How do you go about that? Out-of-state drivers.
Yeah, so I usually will request a DMV hearing anyway, again, because I'm handling the criminal case. Generally, most states are not going to take action against a person's license from administrative action. It's usually going to require a conviction. So as far as the consequences to the person, you know, maybe it has no consequences not doing the DMV hearing. But if you really want to win your case, you're going to do the DMV hearing. So I will request it in 99.9% of the cases, as far as I can recall. And then I did want to mention one thing else. What was it? I don't remember, but it'll come up to me. But go ahead. Any questions at all? Was this supposed to go? I'm sorry. Was this supposed to go to 1 or 1:30?
I was thinking, let's go. We could go. It was going to go from 12 to 1, but we could go to 1:15 and have a hard cutoff at that time.
Okay. So first,
that works for everybody. If somebody wants to stay longer, put it in the comments and we can read them.
If you have a specific question, I'm happy to answer that. A couple more things. So do not be afraid to negotiate with the DMV hearing officer. I think a good argument could be made that technically they are not supposed to be negotiating. However, if you have a refusal but you have a chemical test result. Your client is in a much better position if you concede on the 0.08 administrative suspension than they are if they get stuck with a refusal. So even if you think you got a good argument on the refusal, you may consider not going forward with that if they'll agree just to go forward with the administrative suspension. That's something that you could do. Another thing important to do is look at the DMV 367 form. What kind of notice is being given? If the case is being treated as a refusal, but it's not marked as a refusal, it's not marked at all, which is not uncommon, then you would argue, you object and say, hey, you know what, this can't go forward as a refusal. They could cure that. However, that's a point in time right there. You need to take advantage of trying to get that done. It's getting a 2-year refusal knocked down to a suspension knocked down to a 1-year suspension. That's something that could really have an impact. So if somebody has a prior and they pick up and they got a refusal, it's going to be a 2-year no drive for that person, which is just incredibly, penal, very, very harsh penalty. And so one of the things you could do is try to get that knocked down. There is a case on point, and I included it in my administrative review. I would encourage people to do administrative review. So most people are going to say administrative review is useless. I'm here to tell you it's not. I'm here to tell you that I have had cases reversed on administrative review. I'm not saying that it's a vast majority of the cases or even a majority or close to a majority, but because it's such a simple thing to do, it's $120 cost to the client. You may elect to charge them additional fees if you put it properly in your contract. But that administrative review is something that should be done. I will use the administrative review sometimes for the purpose of doing something. It could be, I want that hearing officer, his baloney that went on in that hearing, I want that public. I want that being reviewed by somebody so they see what this hearing officer's up to, so I don't have to deal with it again. So I may do an administrative review for that purpose, because remember, it's part of my universe, is my practice, and I'm going to be going back there. And if you're going back there, you're going to want to, take control of this process. The administrative review can be something that's detailed. It can be something very simple. Technically, the administrative review is supposed to be, please do administrative review. Here's a check for $120. And I think a lot of people kind of hear that. I don't. The 3 that I included are pretty simple. They're not really aggressive, strong ones. They're pretty simple. And as far as legalese is concerned, there, like, again, I try to make a point, and then I point to one thing, which is actually the issue. The issue, and I think one of them I gave you is a 15-minute observation period that wasn't there. Another one had to do with the fact that my client was only admonished for a 1-year suspension, not 2, and therefore the hearing officer is wrong to do the 2-year. And then offhand, I don't remember what the other one was. I also included a writ. So there is an administrative writ. I will mention something really quick about administrative writs. So typically on a first DUI, I'm not going to be doing or encouraging a client to do an administrative writ. It's a lot of work. You can take what I have and you can cut and paste it, and it's still going to be a lot of work. It's just a lot of work. So you're going to have to charge a client a lot of money for that. And I don't know that you're going to have the benefits to the client on a first DUI. However, if there has to be no disruption in licensing, if you're dealing with a commercial driver, whatever the case is, if you file a writ, you do have the ability to ask for a stay. The stay, if it gets granted, now you can get your criminal case done. Now you can get that case out to trial. You're helping that client in another way. If you have a multiple DUI, it becomes more difficult to get the stay, certainly, but they're doable. And a lot of times they won't. You do it by an ex parte request of a stay in addition to the actual writ, and sometimes the attorney's office or the attorney general's office, won't challenge those. Another reason to file writs. Many of my writs have not gone to hearing, because after filing the writ, or even before I actually, go forward with the writ, I'll send that brief over to the Attorney General and have or actually with the DMV attorney, not the attorney, the DMV attorney, and their legal division, and get them to agree to the set aside. You know, and then you can use that writ process to do things like, you know, if you need a stay, you know, put it out there for the court, put a scram device, put an interlock device on the car as a condition of that stay. So, you know, you got to use the whole process. You got your investigative process, you get your hearing process, you got your administrative review, you got your writ. This becomes a simple little thing of a DMV hearing becomes a big deal as part of representing your client. And, you know, it's why, you know, some attorneys, they don't charge a whole lot of money for a DUI case. It's because they're not contemplating doing this kind of work, because they're not gonna. And the reality of it is, you know, they shouldn't even be taking the case, because this is the kind of work that has to be done in order to adequately represent your client and competently represent your client. So you should be ready to do all this stuff and take advantage of it. So go ahead.
Yeah, with that, I mean, we're about, you know, 1:17. So thank you to our speakers. Thank you to everyone who attended. And thank you for everybody who asked questions as well.
All right. Thank you.
Thanks, everybody. Really appreciate it.
Hope it helped.
Have a
If
great
anybody has any questions, DMV questions, I get calls all the time. Give me a call. My number is 925. That's my cell. 925-787-6475. Text me. My email is peter@jjlaw2.com. I get DMV questions, DUI questions all the time from attorneys. Don't feel bad. Give me a question. I'm good. I'll do the best I can to help you out. Okay?
And of course, guys, the same goes for me. On that brief, I attached all my informations on there. Panagiotis Prountzos, but I didn't want to make this confusing. You guys can call me Peter as well. So feel free to give me a call with anything you guys need.
All right. Thank you.
Awesome. Great. Thanks, you guys. Have a great weekend.
Thank you.